Hey everyone, my name is Eddie, and I would like to welcome you to this session, which we'll just call Initial Impressions of the California Bar Exam for July 2016 for the Civil Procedures question. And of course, we're going to talk about the choice of law issue. So, quick background, you had here a plaintiff who seemed to be a foreign entity, and he was suing two defendants, and one of them was a foreign entity, and one of them was a citizen of a state. That by itself, no big deal. That's been tested in the past. But what did make this question significant is that the state bar used the term California court. It took place in a superior court of California. And usually these matters take place in state A, state B, or state X, of course, for exam purposes. So you had two camps here, two camps of examinees with the different choices of law. The first camp used FRCP, the Federal Rules of Civil Procedure, or they did not mention any choice of law at all. And the second camp mentioned the California Code of Civil Procedure, or just the California rules. Again, I have not seen the exam yet. It has not been published, so these are just initial impressions. But let's read the instructions. And what we're going to do is we're going to look at the February 2016 exam because, of course, the July one hasn't been made public. And let's see what it says here as far as the choice of law. Unless a question expressly asks you to use California law, you should answer according to legal theories of principles of general application. Translation: if they ask you to use California law, use California law. Otherwise, use principles of general application. So, of course, we go on to two questions here. For this particular exam, that they say use California law, and the answer is no. So don't use California law. Of course, that's just the initial impression. There's more to this discussion. The second question is this: is the FRCP included within the definition of principles of general application? Let's look at the National Conference of Bar Examiners. Since the State Bar of California adopted the MBE, and the MBE is produced by the NCBEX. Let's go to that site now. So, I want to know if the NCBEX tests principles of general application, and if they do they explicitly test the FRCP? Let's look at the scope here. It says answer according to generally accepted fundamental legal principles. So that kind of sounds like principles of general application because the words general and principles are included. So yes, we can make the determination that the NCBEX does test principles of general application. Now the next question is this: is FRCP tested on the MBE? And let's look at, again, the NCBEX with that long name. Let's see now. So it says here, it says examinees are to assume that the application of the Federal Rules of Civil Procedure is to be tested. So the answer is yes, the FRCP are principles of general application as per these bar examiners. So what is the conclusion? The answer is yes, you should have used FRCP, or you should have not even mentioned FRCP. But does this end the discussion? And the answer is no, it does not end the discussion. And I'm going to drink some coffee. And then, of course, that was for dramatic effect here. Okay, now the next question is this: does it even matter if you use California law? Because, of course, remember, for these exams, your analysis is heavily considered. So let's keep exploring. Let's look at the scope of the bar exam. And again, let's go to the State Bar of California here. And future lawyers, scope of California bar exam. And let's look for civil procedure. And it says Be prepared to discuss the differences between the federal rules and the California rules, especially where California um, procedures have no specific counterparts in the federal rules. So we're looking for the differences here. That's what it's saying. So for those of you that did apply California law, were there any differences between the California rules and the FRCP as far as like the main issues were concerned? And the exam has not been made public, so I cannot determine for sure. But here are some issues that did appear on this particular exam. You had personal jurisdiction, you had subject matter jurisdiction, you had diversity, and you had removal and probably remand to the state court. There might be others, I don't know. Again, I have not seen the exam, but ask yourself, were there any differences between the California rules and the federal rules? It may be the case that there were no major issues and they did not have any differences. So in that case, it did not matter if you used California rules. And again, the bar graders are going to look at your analysis. And let me step back away from this for now, and I'm going to just mention two quick side notes, and then we'll return to this discussion on the choice of law. Okay, I'm going to just zoom in. Okay, so if you have not taken this exam, remember to apply CYA when you approach these exams. You might need to apply CYA. What does CYA mean? It means cover your ass. So it means that there might be a situation where you might apply a dual track conclusion, where you briefly state two conclusions. For example, under the federal rules, you have this conclusion. Under California, you have this. Okay, and also as a side note, if any defendant is a citizen of the foreign state, removal will not be proper, and the case will usually be remanded to the state. And I think that was the case here for this particular exam, but without all of the facts, I cannot give a definite answer to that. Okay, now let's go back to the exam, and I like this discussion. Let's keep at it. Think about this. Has there ever been a case where a California court has been an issue here for civil procedure? And the answer is no, at least not in this century. In the last century, maybe. I don't know. And I don't have access to those antique bar exams. And another question is this. Has there ever been a case where people answered the law in so many ways? And if so, how was the exam scored? And the answer to this is yes. There has been a time where a law was tested and so many different answers were given. And I point this out because it may be the case here where a lot of people didn't mention the California rules and the answers are going to vary. In such a case, the bar graders are going to focus on the analysis. And how do we know? Okay, let's go back to where that happened. And actually, it was this year, February of 2016, question 6, and it was a Uniform Commercial Code question, and 2207 was at issue. Now, keep in mind that 2207 is one of the most difficult areas of law, even for sitting judges. So you can imagine how the graded exams looked, how they looked like. I was like, oh my God. I mean, they were just all over the place. And the bar graders did give passing scores 65 and higher, even when 2207 was not applied. And you can look at bar essays, and all these answers, these responses just had different answers. Even the sample answers from the state bar, they applied different legal theories. So, and also you had people misapplying the law, and they were still given at times passing scores. But why did the bar graders do this? Again, it's because the bar graders are concerned with the analysis. And let's go back again to the instructions of the state bar. Okay, here we go. It says here they want you to demonstrate your ability to analyze the facts. Okay, it says here again your ability to apply the law, and apply is just code word for analysis. They want to see an analysis. And again, it says proficiency in applying the legal principles. Again, analysis. And state fully the reasons. Again, they want to see analysis. This is heavy on analysis. So the point is this: don't lose sleep because you're thinking of whether you applied California law or you didn't. At the end of the day, it's your analysis that is going to matter. So I do want to wish everyone that took this exam best of wishes. I hope you passed. And remember, stay powerful and beautiful. Until soon.